Hello everyone. Welcome to the MOOCs program on Criminal Justice Administration. Hope you have been referring to the various modules on Criminal Justice Administration which are being uploaded. I am Dr. Upma Gautam, Assistant Professor in University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, Dwarka. Today I would be discussing with you review procedure, and thereby in review procedure I would be discussing revision. As you all know that there are various review procedures given in Cr.PC, Criminal Procedure Code. You must be knowing that there are two review procedures given in Cr.PC. One, appellate jurisdiction, and secondly, revisional jurisdiction. The learning objectives of this module would be to accustom you to the revision proceedings before Session Court and the High Court, to acquaint you about the nature and scope of such proceedings under the Code of Criminal Procedure 1973, to expose you about the various orders that can be entertained by the courts in revision proceedings, to acquaint you with the difference between appellate and revisional jurisdiction, to explain to you about the various limitations as to the revisional jurisdiction. So first of all, I would like to introduce you by the various reasons for which the revision provisions are present in procedural code. The first reason why revision procedures are there is because the human judgment is not infallible, and despite of all the provisions to ensure a fair trial and a just decision, mistakes and errors are possible. So, to avoid miscarriage of justice, in cases where no right of appeal is available, review procedure known as revision is provided. Such procedures are contained in sections 397 till 405 Cr.PC. These are discretionary powers but are subject to certain limitations by certain provisions which I would be discussing in the later part of my module. Now, the other reasons which I can attain to these revision proceedings are revisional powers entrusted in superior courts, by which the redressal mechanism is available to an aggrieved person against flagrant misuse of powers by inferior courts, thereby causing miscarriage of justice. So in short, the revisional jurisdiction is for all intents and purposes the power and the duty of the superintendents and correction. Now, after discussing the reasons why revision proceedings are there in Cr.PC, I would like to give you an idea about that what actually is revision. Revisional jurisdiction confers power upon the superior criminal courts, and it confers a kind of paternal or supervisory jurisdiction on the superior courts. Then it is a controlling power, and it is a controlling power of the superior courts, which is discretionary. Then next is that the revisional jurisdiction is normally to be exercised only in exceptional cases. Now this is very important because there are other provisions in Cr.PC which deals with the similar kind of provisions, which again I would be discussing in my later part of the module, amongst of which the common are and widely used are section 482 Cr.PC and article 227 of Indian Constitution. Now, coming to the provisions given in Cr.PC, section 397 to 405 I have discussed earlier also that it deals with the power of revision. Section 399, 400, 401 respectively, powers of revision of a session judge or additional session judge and the High Court. And section 397 along with 401. Now this is very important because 397 has to be read with section 401, and which empowers session judge and the High Court to call for any records of the subordinate courts and during any proceeding which are going on the subordinate courts for the purpose of superintendence and for the purpose of correction. Now section 398 empowers them to order further inquiry under certain circumstances. Section 397, which deals with calling for records to exercise powers of revision, basically it talks about the powers that are being invested in High Court and Session Court for dealing with the revisional jurisdiction, in which certain proceedings are included and then the powers of revision conferred in this subsection, one limitation that is given in this is that there would not be any revision which would be done regarding interlocutory orders. Now, what are interlocutory orders? I will be dealing them again in the later part of my module. Now, in an application under this section, first, the applicant has to choose between the session court or the high court. That meaning thereby that you cannot go to both the courts one by one. You have to choose either session court or the high court, and you can only once apply there. So this is being dealt in section 397. Now coming to section 401 CRPC, which deals with the High Court's power of revision. Section 401 deals categorically with this power of High Court and invests all the powers of the appellate court in the High Court when it is exercising the revisional jurisdiction. Secondly, the important point that is being dealt in this section is that no order of acquittal can be converted into that of conviction, and more importantly, no order in this revisional jurisdiction can be passed to the prejudice of the accused without giving him or her the power of, without giving him or her the opportunity of being heard. Now, as far as section 399 is concerned, it is talking about sessions judge power of revision, which actually imparts all the powers which are available to the High Court, then to the session court also, and thereby meaning that both are having concurrent jurisdiction by virtue of CRPC provisions. Section 400 CRPC again deals with the power of additional session judge, saying that an additional session judge shall have and may exercise all the powers of a session judge under this chapter in respect of any case which may be transferred to him by or under any general or special orders of the session judge. So, when I have discussed all these provisions, you must be knowing that very wide and discretionary powers are being invested on the courts and on the revisional courts by these provisions, but they are circumscribed by certain limitations, which again is a part of module and would be discussed in detail in the coming part. Now, the next thing which I would be dealing with is when a revision can be filed. Now, as far as filing of revision is concerned, a revisional power can be exercised by the High Court or any session judge if the following conditions are satisfied. First, the proceeding must be in that of a criminal court. Second, such court must be an inferior court. Third, such court must be situated within the local limits of the jurisdiction of the revision court. And the last, the purpose for which the records are called for should be one to enable the revision court to satisfy itself as to the correctness, legality and propriety of any finding, sentence or order recorded or passed, and as to the regularity of any proceeding of such inferior court. Now, I am switching on to my next part of this module, that is scope of revision. Now, before that scope is discussed, I would like to deal with certain terms that are being used in the provisions which you need to understand categorically, clearly, so as to understand the very wide powers that are being given to the courts in the provisions of revision. Now, the first is proceeding. Now, the term proceeding cannot necessarily be said to have any reference by itself to the commission or trial of an offence. It cannot be given such a restrictive significance so as to include only judicial proceeding pertaining to the commission and trial of an offence, and thus will include any judicial proceeding taken before any inferior criminal court. Now, next, what is inferior criminal court? Now, inferior criminal court means judicially inferior to the High Court or the session judge. Then, while discussing the scope of revision, the next thing which you need to know is finding, sentence or order. Finding includes a finding of conviction or acquittal. Sentence means a direction by which punishment is prescribed and meted out. And order covers commands or directions that something shall be done, discontinued or suffered, but it does not include sentence or finding. Example, order of dismissal and discharge, refusal to commit, refusal to stay, or to quash the proceedings. Now, next would be correctness, legality, and propriety. I hope when I was discussing section 397, you must have gone through all these terms in subsection 1 of 397. So whatever terms I'm being discussing right now, may it be proceeding or the term correctness, legality, propriety, inferior courts, that all terms are used in section 397 subsection 1. So you can just go back to section 397 and refer it. So here I am dealing with this. So correctness, legality, and propriety means legality and propriety, they include questions of law as to whether a finding, sentence, or order is legal or proper, having regard to the evidence. The word correctness, please just make it sure that it does not mean that the session judge or the High Court may inquire whether the finding was acceptable to it on a balance of the evidence recorded in the trial court. The correctness of the finding, sentence, or order also implies a legal defense, such as finding being based on an entire want of evidence or being incorrect in the sense that the witness may have given a different statement to what the court may have recorded.